You have just been accused of sexual assault, and I know exactly how that feels. As a lawyer, I have personally sat across from hundreds of men who are watching their entire lives crumble in real time. And sex crimes are the absolute worst. One minute, you're living your life, and the next, you're staring down a charge that carries the worst possible stigma in our society today. I know you're probably thinking, this was consensual, or I know, I didn't do this, or maybe this is a misunderstanding. I can totally fix it if I can just explain my side of the story. Stop. Just stop right there. Here is the cold truth. In the eyes of the public, the police, your prosecutor, and the judge, the moment that accusation is made, the presumption of innocence has just gone out of the windows, regardless of what you're told. If you handle this incorrectly, if you make mistakes, you're not just facing jail time. You're facing lifetime sex offender registration, prison sentences that could span decades, and a label of a predator, a sex offender, that could follow you until the day you die. My name is William Pernik. I'm a criminal defense lawyer here in California and the founder of the Pernik Law Firm. I have devoted my entire career to standing between my clients and a system that wants to destroy them. And today, I'm going to share with you 7 crucial steps, 7 battle-tested tips that I give almost every client facing sex crimes allegations. And I'm going to do this for you so you too can survive this nightmare and fight to protect and preserve your future. Number 1, the interview trap, the lies, the lifelines, and the Reid interrogation technique. I'm going to start with the most critical rule. Do not talk to the police. In sexual assault cases, detectives are not just asking questions. They're not your friends, and they're certainly not there to hear your side of the story to clear everything up. In these, unlike other types of cases, you're going to be questioned by experienced sex crime detectives whose only job is to make sure that you look guilty and to extract from you a confession that they can hand to the prosecutor to use in court. Now, to do that, the cops are likely going to use a powerful psychological weapon called the Reid interrogation technique, or some variation of it. The Reid interrogation technique is a method designed specifically to break you down and force a confession out of you, regardless of whether you actually committed the crime or not. Here's how it works. First, the police officers are going to isolate you in a small room to increase your anxiety. Then, they're going to lie to you. In the United States, police officers are actually legally allowed to lie during an interrogation. They don't call it a lie, they call it a ruse. But it involves them saying things to you that aren't true. For example, they can tell you, hey, we found your DNA, even though that never happened. They can tell you they have video footage that doesn't exist. They can make up statements from your accuser that can get you upset and riled up and force you to search for answers or say things that are just not there. Then, the officers offer you a lifeline. This is where the trap lies. They will invite you to minimize the crime so that it's easier for you to admit to some part of it. For example, they could say, hey, look, you seem like a nice guy. You're not a monster. Maybe you just misread the signals. Or they could say, hey, maybe she let you on and things just got out of hand. They could say something like, hey, we just want to hear your side of the story so we can clear this up, and if you didn't do anything wrong, you can go home. They often say, hey, listen, I do believe you. Is it possible you may have touched her breast or buttocks by accident? You don't seem like the kind of person who would do it intentionally. When police officers ask you questions like this, what they're actually doing is tricking you into agreeing to a lesser version of the story that they know is not true. But the moment you agree to that lifeline, the moment you say, yeah, you know what, maybe I did misread the signals, or maybe I brushed up against her accidentally, even though you know that never happened, you have just confessed to a felony. You've just made it easier to convict you. Now you might think, hey, William, I'm smart. I know better. I would never confess to something I didn't do. Wrong again. Innocent people actually do it all the time because of the psychological pressure, which is specifically scientifically designed to be unbearable. In fact, according to the Innocence Project, almost 30% of all people exonerated by DNA evidence after spending years in prison confessed to crimes they never committed. Think about that. These were innocent people, men and women, who were tricked into agreeing to something that didn't happen or signing their own lives away. Do not become a statistic. Don't listen to them. Don't go for it. Silence is not an admission of guilt. It is your shield. Your only words during an interrogation should be, I want a lawyer. Trust me or not. But if you don't, you're going to end up paying a high price later. I guarantee it. Number 2, the pretext call, the deadliest law enforcement method in California. Now, guys, this is the tip that saves lives, and almost nobody knows about it until it's too late. In California, sex crime investigators use a technique called the pretext call. They will generally have the accuser call you on the phone, or perhaps send you text messages. It could be a police officer impersonating the accuser, sending you messages directly. Or they could be sitting right next to them, silently recording everything, coaching them, feeding them questions. Questions like, "Why did you do that to me?" Or, "I told you to stop. Why wouldn't you listen?" In one case that I handled, the police stooped so low that they actually had this woman pretend that she was horribly traumatized and had to spend years seeking therapy, that she was suicidal. And all she was asking my client to do is just to say, "I am sorry." Why can't you find the decency to admit what you did to me? Why can't you just say one simple word, "I'm sorry," so I can move on with my life? And it's human nature for us to want to comfort someone that we know. All of us as humans feel awkward. We want to de-escalate the anger. And so when you're in this kind of situation, it's very tempting to say, "Hey, I'm sorry. I really didn't mean to hurt you." Or, "I'm sorry. I misunderstood you." Boom. The moment you say that, game over. To a jury, in the hands of a skilled sex crimes prosecutor, that "I am sorry" is going to be a confession of guilt. And I have personally seen scores of innocent men and women convicted solely because they apologized to end an uncomfortable phone call, just because they wanted to make it stop. Now, it also goes without saying, coming from a lawyer, it's stupid to apologize for things you have not done, especially when this is in the context of serious accusations with serious legal consequences. But I also know this is against our nature. Men in particularly are conditioned to say, "I'm sorry," just to make an uncomfortable moment with an upset female go away. We think of it as being a gentleman, but the law doesn't look at it that way. The law treats it as a confession. So don't do it. Either listen to me or you're really going to regret it later. So here's the rule for you to remember. If you ever find yourself in a situation where someone's accusing you of a sex crime you didn't commit, do not answer the phone. Do not reply to the text. Do not try to find out more on your own. Don't respond to DMs. If the accuser reaches out to you, assume the police are listening. They probably are. Block that number and either find a lawyer or call your lawyer immediately. Next to you saying, "Are you crazy? What the f are you talking about?" which almost no one thinks about in a moment under pressure, and is exactly what most of us would expect an innocent person to say. This advice that I just gave you is probably the absolute smartest thing that you can do. Number 3, the no corroboration trap under California law. Mere accusation is enough. Now, this is the most terrifying legal reality you must understand. In California, you can be convicted of a sexual assault felony based solely 100% on the testimony of a single accuser if the jury believes them beyond a reasonable doubt. Many people mistakenly believe, because of the seriousness of the accusation, that to file charges or get a conviction, the prosecutor needs to have proof. And in their mind, it constitutes DNA evidence, medical exam, or some sort of corroborating witness. That is simply not true. Sure, these things make convictions easier, but they're not legally required. Our laws allow prosecutors to rely entirely, 100%, on the statement of the accuser, even when physical evidence is not available or the report is delayed, sometimes for years, sometimes for decades. This is a complete shift in a battlefield. In most criminal cases, the jury focuses on physical evidence. It craves it. But in a sexual assault case, the entire fight often hinges on credibility. The moment that accusation is made, the defense attorney's job is not just to find evidence of innocence, but to aggressively and methodically challenge all of the inconsistencies and weaknesses of the accuser's story. You have to do that to raise reasonable doubt. Otherwise, your client gets convicted and goes to prison. This is exactly why your defense must be proactive and immediate. As lawyers, we cannot wait for physical evidence to appear. We have to start working immediately to expose those inconsistencies, to find the digital timeline, to prove consent or alibi or lack of intoxication, and to present a coherent, persuasive, factual counter-narrative to the system that's often simply predisposed to believe whatever the accuser says. And never forget, without corroboration, their story is the entire case. Your defense has to attack it and dismantle it. Otherwise, you're going to go to prison. Number 4, preserve the digital timeline and do not delete anything. When an accusation drops, the panic typically sets in. Your first instinct is going to be to scrub your phone. You're going to want to delete the Tinder messages, the photos, the late night texts, whatever it is that you're embarrassed of or don't want your wife or friends or parents to see. I'm sure you have so many regrets. You just want to make this whole chapter of your life involving this other person disappear. Don't. Do not delete a single text. Do not erase your phone. Preserve every shred, every fact, every single pixel. If you don't want to hold on to it, fine. Bring it to your lawyer. They can make a forensic copy of it. In modern sex crime defense, your phone sometimes can be your best friend, your best witness. We may need to show the context, locations, history, messages. Was there flirting beforehand? Sexting? Were there hookups in the past? Did she send you a text afterward, acting normal or happy? Do you guys have Uber receipts showing you went to breakfast together the next morning? Things that challenge the credibility of this story. What photos did you send to each other? What fantasies did you swap? If the accuser's story reads just like the fantasy the two of you had been acting out, does not necessarily mean the person is lying, but it sure helps to support your story, the true version of what may have happened. There is so much more. But if you delete these things, if you destroy them, not only do you lose your best defense, but the prosecutor could also point out that you're destroying evidence. They can tell the jury, if he is innocent, why would he need to reset his entire phone? Why would he need to format the hard drive? Why would they delete all of the messages? What was it that the defendant was trying to hide? Don't do that. Bring your phone to us. Bring it to your lawyer. We can download it and keep a clean forensic copy. We'll hold on to the good, the bad, and the ugly. And in the he said, she said case, that digital evidence is often the only objective truth that we have and only objective truths that we can present to your jury to prove your innocence. Number 5, challenge the trauma-informed bias. There is a buzzword in law enforcement right now called trauma-informed investigation. On paper, that means treating victims with respect, and all of us agree it's a good thing. But in practice, what it often means is that investigators suspend their critical thinking. They're trained to interpret inconsistencies in the accuser's story not as lies, but as signs of trauma. For example, if the accuser changes the story and says something that contradicts what was said earlier, trauma. If they forgot key details, trauma again. What if the accuser waited months to report or years? Trauma. This can get even worse with children. There is an outfit out there that pretends to be child psychology experts. They travel around the country and testify that virtually anything the child does or says is 100% consistent with that child being molested. Don't believe me? Go online. Look up CSAAS, Child Sexual Abuse Accommodation Syndrome. This is the theory that can be used to prove almost anything in a case. Once this trauma-informed bias sets in, the cops stop investigating. They stop looking for exculpatory evidence. They don't interview witnesses who might contradict the accuser's story. And if this isn't handled correctly in court, your jury is going to do the same thing. A good defense attorney, on the other hand, identifies this bias, recognizes it in the reports in the investigation, attacks it. We demand the body cams. We interview the witnesses the cops ignored. We look at the security footage they didn't bother to pull. We read all of the messages, the clean ones and the dirty ones. We don't accept the police report as holy scripture. We treat it as a biased document that has to be scrutinized and dismantled. And you better believe it. We do get deep in the mud with those text messages, with those screenshots, with those videos, photos, and all the wonderful digital crumbs that we hope you had preserved for us to look through. Number 6, character matters. This is your shield, and that could be the government's Achilles heel. Now, this is the part that will feel the most uncomfortable, but believe me, it's absolutely necessary. When you come to court on allegations of sexual assault, you have to come prepared to show who you really are and not who the government is trying to portray you as. I know it's difficult to ask support from your loved ones, from your friends, from your coworkers, but being convicted and having to hide from the people who care about you will feel a lot worse. We need character evidence to demonstrate who you really are and to show that you're not the kind of person who has the moral character to commit these crimes. Equally important is digging into the accuser's background. Oftentimes, it's kind of like mining for gold. You do have to go through a lot of dirt and a lot of rocks, but occasionally you get lucky. You find a nugget that could change everything. When we do these cases, our investigation will always look for evidence of prior dishonesty, bias, or motive to lie. This could include, for instance, a past accusation that the accuser made against somebody else during a custody battle that was proven to be untrue. It could include undisclosed mental health issues that affect memory, perception, cognition, drug addiction, or personal drama that shows a motive for revenge, or maybe financial gain. All of these facts and many, many more, when brought to light, can really show a jury that the accuser's story is not reliable, and that her testimony or his testimony cannot and should not be believed beyond a reasonable doubt. I know it's embarrassing. I know you don't want to get other people involved, and you may not want to do these things. You may not want to do it because it's expensive, or it could prolong your defense. Or maybe you think this whole story, this whole case is so ridiculous, no one would believe it anyway. I strongly suggest you listen to this part so you don't find out how wrong you are the hard way, because I've seen that happen. Number 7, hire a specialist, not a generalist. This is not the time to hire the guy who handled your buddy's DUI or your cousin's shoplifting case. I get it. You think this whole thing is bullshit. You were there. You know what happened. How hard, after all, could it be for a good lawyer to disprove a lie? Real talk. Sex crimes defense is a highly technical legal field, and it is not for the faint of heart or those lacking experience. Your prosecutor is going to be especially trained to convict, and they follow persuasive, battle-tested scripts that they use in a case after case after case, leading to convictions. To have even a chance to stand up against the machine, you're going to need to have a lawyer who understands many things that are common in sexual assault cases. SART exams, how to read a sexual assault response team medical report, how to find lack of injuries or interpret findings. Toxicology, how to analyze blood alcohol levels so you could prove consent was legally possible, or you could understand the extent to which respective parties were impaired. Psychology is huge when you do trial work in these cases. How do you cross-examine an accuser without looking like a bully, but still exposing these lies effectively? And much, much more. I've had clients come to me after firing a generalist lawyer who was pushing them to take a plea deal just because they were terrified of the charges and didn't know what they were doing. I've also seen people with inexperienced lawyers who took cases to trial and lost and ended up with decades in prison. In one recent case, we had a client who had lied to police about what happened. There was an eyewitness who claimed he assaulted the female, and there were lots and lots of injuries on this woman, suggesting a violent attack. But we did not accept the police report as gospel. We investigated. We used the same tools I discussed here, and we were able to prove that the victim herself was violent, that she had a history of falsely accusing others, including her own family, and at the end, that it was our client, and not the woman who was actually the true victim of an assault. We were even able to prove that the so-called eyewitness was a co-conspirator and was part of trying to attack our client and rob him. Ultimately, our client spent some time in custody, but he gave us the time to work up the case, and he was found not guilty. Case was dismissed. SART reports, toxicology, psychology, pretext calls, all of these elements are just basic tools of the trade. And if your lawyer isn't talking to you about these things, or is not prepared to answer your legitimate questions about them, it might be time for you to consider a change before it's too late. All right, let's recap 7 rules to survive a sexual assault allegation. Number 1, stay silent. The police will use psychological tricks like the Reid interrogation technique to generate false confessions. Do not talk to them, and do not fall for the lifelines they offer. You gotta be aware of the pretext call. Men are conditioned to apologize to upset women. Don't fall for it. You're not alone. The government is there, they're taking notes, and they're listening. The corroboration trap. A single accuser's word is enough to convict you. We have to investigate hard and dismantle their story, but no corroboration is required. Character is key. In a he said, she said case, the jury needs to know who you actually are, and, more importantly, who your accuser is. Fail to show your character and the other person's character, and you're most likely going to get convicted. Preserving evidence, digital evidence. Be careful to not delete anything. Preserve messages, preserve history. Your phone could be a witness and your best friend. Challenge the bias. The investigation is often one-sided. We have to find the rest of the story and tell it in a way that shows how the police were conducting the investigation in a flawed, guilt-assuming manner from the very start. Finally, be sure to hire a specialist. This is a moment that calls for brain surgery, not a checkup. Be sure to get a lawyer who knows this specific field, because if you don't, you're going to be another skeleton in his or her graveyard. Every case is different, but the stakes in these cases, the sexual assault cases, are life and death. Your freedom, your name, and your future are all on the line. My name is William Pernik. My firm is on the mission to ensure that a mere accusation does not become a life sentence. I've recorded this video to help you. And if you found this video informative, please comment below, please subscribe, and always remember, you are innocent until proven guilty. And good lawyers will go the distance to fight to keep it that way. Thank you for watching. I'll see you next time.